And we've seen it on the news where there are governors who have all said this isn't fast enough. The response was not fast enough. So I absolutely think if there's going to be some sort of reform, that's where we should look. We should look to see, did the national contingency plan work? And was there a foreseeability, that's where I defer to you, Tim, but was there a foreseeability that there's a potential blowout of this magnitude? And why are we waiting 2 or 3 or 4 weeks? Not days, but weeks, to figure out how we're going to cap this well. That to me shows a huge, significant gap in safety regulations.
And I think that too goes to this idea that one of the responses from Exxon and whatnot is this idea of throwing money at a problem, but developing a comprehensive plan on addressing the problem itself or prevention of the problem is something that we've not learned, I don't think, from past experiences with Exxon and Texas City Refinery. And it's like these funds are great to be able to get feet on the ground, cleaning up the mess. But as far as coming up with a comprehensive regulatory approach to really contingently handling these things, prior to disaster occurring, is something that definitely I hope will be looked at. And I mean, you wonder how many disasters can occur before we start trying to put together some comprehensive plan.
I have to agree with Professor Blake on that, in that we are always a reactive society. Every time there's a problem, that's what we do. We come forward, we do some legislation. In the criminal area, it's caused a lot of problems because we have over-criminalization. We have over 4,000 federal criminal statutes. I mean, you had Sarbanes-Oxley because of an incident. I can point to so many pieces of different legislation that came out of problems, as opposed to taking an approach of an educational approach and dealing with the issue prior to becoming a problem. And I wish that there would be more concern about looking at things from that type of an approach and trying to educate people. In this case, I think educating corporate individuals is very important. I mean, a corporation you can't put in jail. I mean, there's no body to put in jail, and the most you're going to get out of a corporation are fines. So I think that looking at that entire construct of corporate criminal liability and the need to educate people and not just be the reactive society, I think would be very helpful for all of these type of things.
And I do believe that other countries provide good models for preventive disaster prevention type approaches, and it kind of bucks against a general trend of pushing back on regulation, I think, in the U.S. and some of the costs getting passed down to the consumer and some of our desire for cheap oil and gas and things like that. But I think there are some other models out there that work, and it brings to mind just a broader point, even broader than BP, is this idea of Hurricane Katrina, that after it happened, everybody's like, well, where's the federal government? Why didn't they respond? It raises an interesting question in some of my areas of research of federalism. Prior to Katrina, what if the federal government had tried to be more intervening in local land use decisions to prevent some of the wetland destruction that ultimately led to some of the economic harm caused by the hurricane? Our state and local governments are very protective of their sovereignty over local land use regulation, and the courts have said that's a quintessential state and local government activity that the federal government needs to stay clear of. And so I think it raises some broader questions about the scale at which we look at our constitutional order to say, how can we reassess these disasters before they occur, and some of the balances of power amongst our federal system to prevent some of these things from happening. It raises a lot of interesting, broader political and legal questions, I think, as well.
Do you think there's a possibility that we'll get beyond this kind of knee-jerk approach that we have to? There's certainly public outcry about what happened. There's this disaster that happened, and there'll probably be, at least on the surface, what looks like tougher safety regulations and tougher environmental regulations. But do you think that there will be an opportunity, like you said, to educate or to look at a model, or will that happen? Or do you think, realistically, do you think we'll just have a series of regulations that may or may not be effective and have the same disaster happen again?
I'm hopeful. I'm very hopeful. I think, and I'll use as an example, the Securities Exchange Commission has recently gone through some major changes because of a Ponzi scheme that had existed for a long period of time that they were totally unaware of. And an investigation was done after it to see what had they missed and why had they missed it. And as a result of it, there are major changes going on in that agency. I can see that happening here. I could see there being some major changes in the regulatory structure and the way it operates as a result of this.
I'd like to think that that's happening. At the moment, all I see is a desire to demonise BP and to exclude them from other future contracts, which just means that we're waiting for another contractor to get into the same mess. I do share everyone else's views about something needing to be done at a more strategic federal level, if for no other reason than I think that the law of torts, as I've already said, isn't able to redress lots of these things. There's lots of people who are going to suffer some form of loss, and the law of torts can't compensate them for it. So even if you're prepared to say, well, let the market work, you're effectively condemning lots of innocent people to having lots of damage which nobody can rectify. So trying to prevent the problem before it occurs is definitely a better solution. I do think that there's one problem that we haven't really mentioned, which is that no matter what regulations are introduced, companies will adjust their behaviour accordingly. And Chrissy has already talked about the nature of the contractual matrix involved here. And one of the reasons, excuse me, one of the reasons for having that contractual matrix is that the parties are able to divide up responsibility among themselves in a way that they believe is both lawful and effective under the regulatory regime that's currently in existence. And the problem with bringing in new regulations is you've always got to be aware that while you've changed the ground rules, that doesn't stop the players changing their behaviour. So when you bring in new ground rules, you've got to foresee that eventuality and decide how you're going to deal with it. And I would go one step further and say that, frankly, things like Exxon Valdez, 9/11, and this blowout, you're quite right, Chrissy, it is a blowout, show that the traditional legal mechanisms often really don't work. I mean, why did we have a fund for 9/11? Because the law of torts is a hopeless vehicle for dealing with the injuries that ensued. Why have we got a fund here? Well, you could say it's because of legislation, but we have a fund essentially because without that legislation, the law of torts would be hopeless. And although we're talking about people dragging their feet, we're not really talking about dragging the feet on the compensation front because we have a fund very quickly. But if we didn't have that fund, we'd be talking about 20 years litigation probably. So I think what we have to do is to recognise that traditional legal remedies and traditional legal ways of regulation simply have been a failure, and we need something quite a lot more radical.